Protecting your brand is an important part of growing your business and maintaining your customers' trust. Your company's name, logo, and tagline should be protected so that no other company can enter the market and use your identity to sell their product or service. One of the earliest steps you can take to protect your brand is to register your trademark. In this video, we'll cover the basics of trademark law, and I'll give you 5 tips to leverage trademarks in your business. What's a trademark? Trademark law prevents businesses from operating under business names or using logos that are likely to be mistaken for the name of an existing competitor. So for a more complete definition, here's how the US Patent and Trademark Office defines a trademark. Any word, name, symbol, or device, or any combination used or intended to be used in commerce to identify and distinguish the goods of one manufacturer or seller from goods manufactured or sold by others, and to indicate the source of the goods. In short, a trademark is a brand name. A service mark is similar to a trademark, but it's used to distinguish the services of one provider from the services provided by others, and to indicate the source of the services. You might be thinking, what's the difference between copyright and trademark law? Copyright and trademark law both protect intellectual property, but they protect completely different things. Copyright law protects works such as poetry, movies, writing, music, video games, paintings, performances, novels, software code, choreography, and architectural designs. Whereas trademarks are names, logos, sounds, shapes, colors, and even smells that distinguish the source of goods or services of one party from those of another party. So here's an example. A computer software program may be copyrighted, but the name of the software is trademarked. If a trade name or logo is protected by copyright law, is it automatically protected by trademark law? And the answer is no. A trade name or logo design might be protected by copyright law, but it is not protected by trademark law unless it is actually used in commerce. And this is because trademark rights arise only through commerce, such as when you offer items for sale or use the trade name or logo in your marketing materials or on your products. Must a trade name or logo be registered with a US Patent and Trademark Office to be protected by trademark law? No. You are not required to register a trade name or logo. You can acquire common law rights simply by using the trade name or logo in commerce. Do you have to be a US citizen to register a trademark? No, but you have to disclose your citizenship in the application when you file it. How long does a US trademark last? US trademark registrations filed today have a 10-year term. And keep in mind that there are periodic requirements to maintain an active registration, and you have to follow those requirements or risk losing your trademark registration. Can you sell or assign a trademark to another person? The answer is yes. If your trademark is registered and you decide to sell it, you can, but you don't have to record the transfer with the US Patent and Trademark Office. Is a US trademark or use solely in the US sufficient to acquire trademark rights around the world? And the answer is no. Trademark rights are territorial. So what that means is if you're registered in the United States, for example, you can enforce it only against those who infringe your trademark in the United States. Now, many European countries have adopted the community trademark, CTM, a registration under the common system that allows the enforcement of rights in all of the signatory countries. The CTM doesn't replace national trademark rights in the signatory countries, but it does coexist with those rights. So if you own a US trademark or have applied for one, you can seek registration in any of the countries that have joined the Madrid Protocol, which is an international treaty, by filing a single application called an international application with the International Bureau of the World Intellectual Property Organization. Now that you know a little bit more about trademark law, here are 5 practical tips to help you avoid violating trademark law with your name or logo. So number 1, do a trademark search before you settle on a company name or logo. You can search for free the federal trademark database called Trademark Electronic Search System, TESS, T-E-S-S for short. You can also leverage Google, Bing, and any other search engines to look for companies using the name you intend to use. And don't forget to do a domain name search to see if someone is already using the domain you want as their domain. Always a good idea to hire a trademark search service, even if you think you're a good researcher. They typically cost several $100s, but cover many more databases than you'll have access to, and will often include an international search, which will be much more thorough. Intellectual property lawsuits can be very expensive. Take care to make sure that you're not exposing yourself to unnecessary risk. Number 2, register your trademark. You are not required to register a trade name or your logo. You actually acquire common law rights simply by using the trade name or logo in commerce. But registering the trade name or logo can help you. Among other things, it notifies others that you assert rights over their trade name or logo and that you're serious about protecting your rights. The registration date also contains the date you first used the mark, which serves as evidence against other parties who you may later allege violate your trademark rights. The other benefit is when you're registering your trademark, you can sue those who infringe your mark to recover damages and also attorney's fees and potentially punitive damages. You can hire a firm or attorney to help you register, or you can do it yourself. The forms for registering are available from the US Patent and Trademark Office. 3, maintain your trademark if you've registered it. If you have registered your mark, continue using it in commerce. Don't forget to use the R with a circle around its symbol once your registration is approved, because this lets everyone know that your trade name or logo is registered. And if you haven't registered, you can still use the TM symbol to let people know that you assert trademark rights in the trade name or logo, but that it's not officially registered. Number 4, you can file a trademark application before you use a mark in commerce. And this is especially helpful for startups because you don't need to wait to use a trademark in commerce. You can file an intent to use application with a US Patent and Trademark Office. Number 5, understand the permitted and prohibited uses when you use another company's trade name or logo. This is important. And this happens often, especially when companies enter into partnership agreements with each other. The partners use each other's trade names, trademarks, or logos. So for example, if I have a small electronics store and I advertise Sony products for sale, I may use the Sony logo in the advertising I place in the local newspaper. Make sure you have the rights to use the trade name or trademark of another party. Don't assume that you have unlimited rights. You most likely do not, even if you are allowed to sell that company's products or services. And similarly, if you let other parties use your trade name or logo, make sure you carefully define how they should use that name or logo and specify any uses that you cannot permit. If you get into a jam or unsure about what to do, always consult an attorney. Want more actionable advice on starting, operating, and growing your business? Click the link below to visit the crowdSPRING Small Business Resource Center.